Hi, everyone. Good morning. Welcome to First Wednesday for Business. I'm Jennifer Burns. I'm head of the Business Insight Center here at the Central Library. And just as a reminder, we provide free market research services as well as free prior art searches for patents and trademarks. So if you have any questions around those, we are the home of the Carlson Center for Intellectual Property, and we can guide you through that process. We also provide free sample examples of business plans. So if you're not sure where to go, as well as access to Live Plan, which prompts you through the business plan writing process. Without further ado, Christine Rogers is going to introduce our speaker.
Thank you, Jennifer. Good morning, everybody. My name is Christine Rogers. I am a business advisor with the SUNY Brockport Small Business Development Center, also known as SBDC. And our center provides free and confidential business counseling to startups, entrepreneurs, and small business owners. And we work and guide you on business plans, projections. We use the library as a very strong partner. Our free services are made possible by funding from the SBA, the state of New York, and our host campus, SUNY Brockport. And our business advisors are available in person, virtually, or by phone. You can make an appointment by going to the sbdcbrockport.org, and that's where you would sign up for the advisement session. Check us out and follow us on the Instagram, LinkedIn, Twitter, and Facebook, Brockport SBDC. So I want to welcome our guest, Jacob H. Zoglin. And Jacob is a partner with the Zoglin Group and chairs the firm's zoning and land use law practice group. Jacob has worked with the Zoglin Group since 2016, when senior partner Mindy Zoglin formed the firm after nearly 30 years of practice. And before joining the Zoglin Group, Jacob worked on environmental and municipal law matters with, I may say this wrong, Bansback? Is that right? Bansback? Zoglin PC? Bonsbeck. And he represents clients in a human rights litigation clinic, worked for the National Labor Relations Board, and interned for a Superior Court judge in Washington, D.C. He's enthusiastically involved in the local and state community. He's an active member of the New York State Bar Association and Monroe County Bar Association, and has repeatedly lectured on and participated as a panelist for continuing legal education courses involving new, interesting, or emerging areas of law advocacy in Washington, D.C. area. Jacob was born and raised here right in Rochester, New York. He enjoys soup making. We'll have to share recipes, skiing, being outdoors, and traveling with his family. And he has two beautiful boys, one 3 and one 2 months old. So congratulations there, and take it away. It's all yours. Thank you for being here.
Thank you so much. And thank you to the library and the Small Business Development Center. I'm going to work on sharing my screen right now, so bear with me for just a second. Let's see if we got this. Try this again. Uh-oh. Here we go. Can you hear me?
We can hear you.
Okay, great. I had accidentally muted myself. Let me make sure that this, is it still sharing the screen?
Yes, it's very tiny.
Okay. Oh, can you make it larger, or do I have to make it larger?
I think you have to.
Yeah, if you can just put it in presentation mode.
How's that?
The same.
Oh, I'm in presentation mode.
Well,
go to slideshow.
Oh, go to slideshow from Maritza. Thank you, Maritza.
way up on top. It's one of the across the bar,
Yep.
and click slideshow.
It says it's going in slideshow mode.
Hmm.
If you go
Oh.
to the bottom of your screen, bottom right-hand corner, you'll see the little slide thing, the little slide icon.
Yep.
And you can, if you click that. And then Jamie suggests, do you have multiple computer screens on?
I do.
Maybe
Yes.
shut them down.
Okay, let me see if, all right. Sorry about this, folks.
Oh, that's okay. That's why we have technology to drive us crazy.
Is this, whoa, is this doing it for you?
It's the same, but you know what? Ooh, ooh. Okay, well, that looks like a spreadsheet that no one wants to read anyway. Oh no, that's bad.
And I can,
Sorry.
so Jacob, I have your presentation if I can find it. If you want to hold on a minute.
Okay.
Yeah, that's not good.
Let me see if I can find it.
All right, so stop sharing, Jake. Oh, good, you did. Okay. Thank you
For
guys for
some
your
reason, it
patience
flipped
and
on my screen.
appreciate your feedback. We're gonna crowdsource this tech problem.
Oh boy. Display settings, here we go.
Just as a reminder, we do send out the slides to you after the program. So in the worst case scenario, you will have the slides later.
Maybe I lied. Maybe I don't have it, but I did. Hang on a minute. Or you can send it to me again, Jacob, really quick.
Okay. Let me send it to you. I'm sorry about this, folks.
I have it. Never mind. I lied. Okay, give me 1 second here. And I'm going to share my screen. Can everyone see that?
There we go.
Yep, looks good.
Okay, so
Okay.
I'm going to be, you're gonna have to say next Vanna White, okay?
All right,
So-
all right. Thank you so much. So thank you everyone for having me. My name is Jacob Zoglin. I'm a partner at the Zoglin Group, which is a law firm here in Rochester, New York. Our offices are located in the High Falls neighborhood, right across from what used to be Frontier Field, is now Innovative Field, and the Monroe County, the MCC downtown campus. So just for reference. So we primarily work in the areas of municipal law, environmental law, zoning, land use, and municipal. So I'm here to talk about how we can help small businesses in and around the Rochester area with things that come up with relative frequency. So one thing that we see all the time for new businesses is people trying to figure out, well, where can I even open up shop? This goes to the heart of local municipal control. Towns, cities, villages have zoning codes, and they say where you're allowed to have businesses, what's residential, what's farming, what's industrial, et cetera, et cetera. So oftentimes people come to us and seek help selecting a location for opening and setting up a business, trying to keep that process seamless, and helping them jump through the municipal hoops. Sometimes it is easy. Sometimes it's like, oh, you're a commercial business, you want to be in a commercial district, no problem. Other times, not so easy. Other times, a business or a development plan doesn't fit so neatly into the zoning code or the rules and regulations. Maybe there's some weird precedent that causes an issue. And so property owners, in those cases, have to sometimes receive additional approvals from the municipality. oftentimes what happens will be you'll be in a situation where you either may need to apply for a variance or a special use permit or some other type of permit or approval from the municipality. Depending on what type of approval you're applying for, the development or approval may require the town, municipality, city, or board, whatever the case may be, to go through an environmental review process that's mandated under New York state law. That process is called the State Environmental Quality Review Act. The shorthand is SEQR, SEQRA, or SEQR, SEQR. And it's funny because like the state will abbreviate it one way and like all the other attorneys in the state will abbreviate it the other way, but that's just the state for you. Business owners sometimes often find themselves facing community opposition when they open up shops too. So sometimes businesses, looking to come into a community, observing that there's, mixed messages. Some people really like having them. Some people are nervous about the impacts. Those are times when they sometimes get us involved to help respond to community opposition, respond to community complaints, or allegations by the community of code violations or other things of that nature. Helping the business stay on good footing and making sure they don't get off on the wrong foot with their municipalities. Vanna? Thank you. And thank you for letting me call you Vanna White. For the variances, this is one of the very common things that we see people, businesses trying to seek. And I see that one of the comments is not everyone understands what a variance or special use permit is. And thank you for that question, because that's exactly where I'm going next. So variances are a way that the municipality can allow certain uses or buildings or properties that don't strictly comply with the zoning code. And there are a couple different types of variances. There's a use variance, which is when the use that you're trying to put the property for to is not allowed as of right under the local zoning code. So where use variance is sought is where an applicant seeks an exception from the municipal zoning code to use their property in a way that's not otherwise permitted. These are really, really difficult to get. You're essentially asking the board, you're saying, yes, I understand this is not permitted here, but because I satisfied this multi-factor test that's established under state law, and the zoning code would essentially affect a hardship that's so substantial that I couldn't develop or use the property profitably at all. There are unique circumstances. The hardship isn't self-created and it's not going to otherwise be problematic in the community. Those are the issues that get considered when a use variance application is received by a board. An area variance application is really similar in that you're asking the municipal board to grant an exception to allow something that's not strictly permitted. The difference between a use variance and an area variance is use is about allowing a use that's not permitted, and an area variance is allowing dimensions, issues about how close you are to setbacks, how tall it is, things of that sort, where the applicant is seeking an exception or relief from what we would consider physical restrictions on their property. Distances, measurements, things of that nature that would not otherwise be allowed under the zoning code. So again, like a use variance, they're going in there, they're conceding, yes, I understand this does not comply with the zoning code, but I'm seeking an exception, what's called an area variance, to allow it to be closer to lot lines, bigger, more area. As with the use variance, there are specific factors the ZBA has to consider. We help with this application by showing that the facts of your application satisfy the elements such that you have a better chance of success in applying for this. And there's a really good reason to have an attorney present for these, because if you are denied a variance, most municipalities don't allow you to reapply for a year. So if you go in thinking, hey, this is a little expensive to retain counsel, it doesn't seem too complicated, there are only 4 or 5 factors, maybe I can do it on my own. I certainly understand the temptation to do that because of costs, but there's a risk that you're not going to understand the issues and present it in a way that gets it denied. And then there's another risk that you might not be able to reapply for a year. So that's a concern when people try to do these things themselves. Certain things that we see where this is caused the need for variance if people are expanding a building into a setback or in making it higher or something like that. Those things are likely going to trigger an area variance requirement. Things like changing a use of a building after it's been purchased or converting a prior use to a new use. Sometimes those will raise potential use variance issues. Next slide, please. I see a question asking someone if a small business is leasing a commercial property and wants to use it for a non-permitted use. Generally speaking, the person who wants to do the use applies for the use variance. So if it's the business will apply. Technically, the applicant will stand in the shoes of the property owner for these purposes. So the tenant, the business owner would apply, but it's important to recognize that they are equitably in the shoes of the landowner. So, for example, like a hardship created by the landowner could end up being imputed to an applicant. I hope that clarifies it, but if there are further questions, I can certainly address them. Special use permits are similar to variances, but they're a little different. For a special use permit, the municipality has determined what uses are permitted. And it did not say that this use is permitted as of right, and it didn't say that this use is prohibited. A special use permit is the municipality saying certain uses are allowed in this district, but they are the types of uses that create special types of concerns. And because of those special types of concerns, they require special oversight. Usually that means imposing conditions that will minimize the adverse impacts on neighbors, right? So the special use permit requirement gives the municipality an opportunity to review a use that is potentially going to have special problems or impacts and to impose mitigation measures. And they'll receive that special use permit application with respect to a specific property in the zoning district. And this can apply to, special types of businesses, special types of activities, or just to run it at all. And similarly with the issues that I discussed with variances, it's really important for special use permit applicants to have an attorney with them so that they can be sure that they're meeting all of the requirements for a special use permit laid out in the municipal zoning code and make sure they're following the procedure and importantly, laying an administrative record for to allow the board a basis to approve them. The administrative record is really important both for the applicant and for, let's say, someone that wants to oppose it, because if you end up in a situation where you don't like the result of a municipal decision on a variance or special use permit, and you end up suing to challenge the decision, either to try to get the denial, annulled or approval annulled, then when that happens, the court can only base its decision on the record that was before the agency. So having a lawyer with you when you apply for the variance or you apply for a special use permit is really essential because they can not just, proffer the arguments that the board will consider and that will be helpful in hopefully reaching the outcome you're looking for. But it also lays the groundwork so that if the board issues an adverse decision and you have to sue, that you go into court with the best record possible, the best chance of success. Because the last thing you want is to spend money on an appeal and go in there with bad facts because you didn't spend the time and attention to building the administrative record. So a lawyer that's paid attention, that's done this before, that knows the nuances and the ins and outs, can make sure that the administrative record is as strong as possible. As I was mentioning, that's true both for an applicant and for someone who opposes a variance or a special use permit. Either way, you're going to want to make sure that the side that you're arguing for has good evidence in the record. So really important to have an attorney with you at both phases of that process. Next slide, please. Seeker. So I had mentioned this a little bit earlier. And to understand kind of how often and how frequently seeker comes up and the how significant it is in the development and approval process for many businesses, I'll give you a little bit of background. So seeker is a state law that embeds into the municipal approval process a environmental review requirement. And it applies to certain municipal actions, certain variance or special use permit requests. And when seeker is triggered, it's triggered for certain types of actions. The municipality has to look at, is this the type of action that's going to have adverse impacts on the environment? And if so, then they look at whether there's going to be small, medium, or large impacts, whether they can be mitigated. They often will go through an environmental impact statement process. There's public meetings, hearings. This is a really important process for a developer or a business to get right. Because if seeker doesn't go well, it can cause the project to stall. It can cause the project to not get approved. It can cause a lot of mitigation measures to be required that can cause hiccups. And it can slow things down a long time. So it's really important for a business person or a developer, a small business, to make sure that they are well prepared for seeker and approach it with an understanding of what's involved, what's required, and knowing what to expect. So it's also a good opportunity for the opposition to try to poke holes in applications. So if you have a project that's controversial, if you have a business that causes impacts, that causes controversies, that maybe in its odors or other secondary impacts that you're pretty sure neighbors or the community or maybe an opposition business nearby is going to come out and try to oppose you. It's important to have good support during the seeker process, because challengers in lawsuits will often raise defects in the seeker process. So it's important to get seeker right from the municipal side, from the applicant side, from the opposition side. They offer opportunities to get it right, to challenge it, and just to make sure that our businesses are harmonious and not causing problem for our neighbors. So we assist with navigating the seeker process, and we can also explain when there are defects in the seeker process, when it needs to be fixed, and when a potential issue with seeker creates a cause of action that could potentially be the basis for challenging an approval. We can also help, just help them make sure it gets done right. So, and another important thing to realize with seeker and with these types of decisions is that if you get an adverse decision from them, you want to contact an attorney very, very quickly, because many of the variance decisions, special use permit decisions, many of those have to be challenged in 30 days. Some seeker decisions have to be challenged in 30 days. There are a small subset of municipal decisions and other types of decisions that have a 4-month statute of limitation. I don't want to get into the nuance of that, but I would just say any municipal decision you get that's adverse, that harms you or your business, talk to an attorney that day or the very next day, because it's possible you could end up having to administratively appeal if it's an administrative decision, or commence a lawsuit if it's a final decision relatively quickly. So if you're in that situation, talk to an attorney quick if you haven't talked to them already, so that, because those things move quick. So next slide, please. So where do the attorneys come in? I mentioned a little bit already, but often the time that we get pulled in most frequently is, in the beginning when people are trying to start their business. Community members may attend a public hearing on a variance or special use permit application, or submit objections based on environmental or other grounds. When our firm gets involved on the applicant side, we can try to issue spot some of those problems, potential issues early, and kind of frame the application in a way that either avoids or addresses them, and be in a position to kind of anticipate community opposition and respond both to their concern, but also to the legal issues involved in the application. From the flip side, obviously, it's really important if you oppose an application to get counsel in at that point, as I mentioned, to build that administrative record. This doesn't just have to be not in my backyard folks, it can also be people that are concerned about a competing business coming in next door. It can be people concerned about how a business is going to affect the community. It can be a lot of different things. But if you don't have your issues raised at this level, you're going to miss an opportunity to have them part of the record. So after approval of a variance or special use permit is also a time where we get involved a lot. This is a really challenging time to get involved, right? If, let's say, you made a variance application, you thought it was a shoe-in, go to the ZBA meeting, and it gets denied. Sometimes we get called after that. And as I mentioned, the statute of limitations for that is really short. So if I get a call, the day after a decision, that already means we got 29 days, right? Because if there's a 30-day statute of limitation. So that means that we got to do the intake, open a file, review all of the materials, the application, the decision, any public record, public comments, and draft any lawsuit in that 30-day period if you want to challenge it. So we get involved at this stage, but I would urge you, if you have something that's important that you're applying for municipal approval for, get the attorney involved early so that they have more than 29 days to get up to speed and file. And it'll help you have a better understanding of the case, and build the administrative record and get everything filed in a timely manner, but also on your terms, right? It's always better when you think things through in advance and execute your plan on your terms. And that can go on both ways, right? Challenging approval or defending. If you think that there's likely going to be a challenge, contact us early so that we can start thinking through it. The same thing is true for an applicant if the municipality rejects a variance or a special use permit application and they want to challenge that. So either challenging an approval, challenging a denial, either way, having an attorney at the administrative level and at the court level is important. Next slide, please. So our help doesn't end just when you get your doors open, just when the business starts. Attorneys are often needed throughout the process of your business. So let's say you needed a special use permit for whatever type of business you were running, and you applied for one with an attorney, and you received one, and you operated your business for, let's say it was a year permit, and now it's time for you to renew. And you think, well, it's a renewal permit, it's just the same thing, I should just do it on my own. Sometimes people really do have problems with renewing a previously granted permit. Or they have problems because the variance expired after a year because they didn't act on it, build the thing that was contemplated by the variance. Either when there's something that's expiring or a permit that needs to be renewed, it's a good idea to just loop in the attorney, reality check your assumptions about it. And if, you want to make sure that if there are timelines and you have to apply for, you meet those timelines. If there are other things that need to be submitted with the application, you submit them with the application. And if a fee is required, the fee is paid. You don't want an application, a permit renewal denied because you left something silly off. And you don't want a variance to expire because, it was 6 months or a year and you didn't finish building the thing contemplated by the variance permit. So it's important just to loop someone in so you don't accidentally lose a really valuable asset like a variance or a special use permit, an accident because you were assuming you'd be able to get the renewal or you were assuming it wouldn't expire. You don't want to make that mistake once. So another issue that we often get involved with after a business is opened is when there is a notice of violation or some other activity or event or allegation that leads either to an environmental concern or a notice of violation from the municipality, often from like a code enforcement officer. So if there's something from code enforcement officer, we may appeal the notice of violation to the ZBA. And if the ZBA has adverse decision, challenge that. Or some people have us, attempt to work it out with the municipality. Some municipalities have good neighbor policies where they really encourage you to work it out. And sometimes it means, defending a client from an alleged violation in town court. And those are things that we can help with too. Either, appealing a code enforcement officer's notice of violation, or appealing a ZBA's upholding of that, or defending in town court, as the case may be. And there are a lot of different ways that can go. Sometimes it's not a notice of violation. Sometimes it's a neighbor that is raising a potential nuisance claim, right? They're saying they're not going through the town. Maybe they're going and right to court and saying, this guy, his activity is maybe causing dust or noise or vibrations or some other activity that interferes with my use and enjoyment of the property. Often, if there's a lawsuit like that, we get involved, and that happens even after a business is open. Obviously, if you feel like something is going in that direction, you want to retain counsel quick because you don't want to be served with something and then fumbling around. In any of these circumstances, whether there's an issue with a previous permit renewal, whether something's expiring, whether there's a notice of violation, enforcement action, neighbor dispute leading to litigation, anything like that, it's really going to be important for you to contact an attorney and get help. This is important to help business owners keep their businesses running, navigate municipal law appropriately, and limit their liabilities. And frankly, stay on good terms with their neighbors and with the towns that they're operating in. I see a question about what kind of jurisdiction does a county have? So counties approvals, it depends on what's being applied for. But oftentimes the county's involvement is going to be limited. So certain types of applications are considered big enough, having more regional impact, that the state has determined that those applications should loop in the county. So for certain applications, I'm not going to get into a huge level of detail what that looks like, but on certain applications the law of the state of New York requires that the municipality, the town, ZBA, town board, whoever it is that you submit your application to, if it's a certain type of application, the law requires that board make a referral of the application to county planning. And that just means that the county planning has an opportunity to comment up on the application. They don't get to approve or deny, but they get to make recommendations, and their recommendations don't have to necessarily be followed, but if they're not followed, there's a higher threshold for approval in some circumstances. So there is an extent to which counties can be involved. That's under General Municipal Law 239M. I'm not going to get too deep in the weeds on it, but just know that that usually the local board, the smaller municipal subdivision, is going to be the one that's going to be making these variance or special use permit determinations. So I think this was one of the last slides I had, but I have a couple of other things that I can share with you. For example, we've been retained by some businesses in Rochester when there's let's say like a Department of Labor issue, like there's maybe an allegation of asbestos or some other type of violation, and the business is concerned about, the impacts of, a potential violation alleged against them by a regulating agency. We can, facilitate communications between the business and the regulator. We can represent the business if they need to meet with the regulator. So those are things that also come up. Other things that come up for businesses is where sometimes local municipalities will adopt laws to try to regulate new or emerging businesses, or businesses that they don't understand all that well. And in those cases, sometimes they'll pass laws that don't make a lot of sense, or that the business owner in good faith can't understand how to comply with. So we've actually represented some businesses in suing municipalities and setting aside laws that were so confusing and hard to understand that the court determined that they were unconstitutionally vague. So that's another issue where we help businesses where they're looking at regulations or laws passed by the town or the county, or whoever is passing the local law, and they're saying, I have no idea what this means or how to apply it or how to comply. And the attorney looks at it and they're like, yeah, this doesn't look like there's a real good way to comply. That can be an issue where, a poorly written law actually constitutes a constitutional violation. And we've had some, I don't want to say fun, but we've had some good cases where we've had unconstitutional laws set aside for being so vague that businesses can't possibly comply with them. And that can be really satisfying for a business to finally get clarity on, if they just want to do this right, how do I do it, right? So that's another example. I can go on some of examples of some of our other cases, but I also want to leave time for questions, because I know that that a lot of business-related issues, municipal issues, tend to be pretty fact-specific.
So,
Gina?
hi, yeah, I asked Jen if I could, because the question's a little convoluted to write it all down. So I have had a situation, and I think I mentioned this in our staff meeting, with a client who was fighting with the pavilion board for a special use permit. My question is, does the municipality have to comply with some standard of law when they deny a variance or special use permit? For example, when banks deny a client from a commercial loan, they have to give a reason why they didn't and a reason why they did. So in that particular situation I had, it was more about personality disputes that kept dragging things out, and initial denials, and costing more and more and more. And so what's the remedy for that? And secondly, is it customary for a municipal board to require the applicant to pay for special professional services in order to process the application? So in other words, my client had to pay $8,000 to hire an engineer for the town, so the town would have some expertise in what the engineer for the client was presenting. So that
Yeah.
to me seemed a little bit wrong, that it had to come out of his pocket. Why wouldn't the town, if they didn't have the expertise, why wouldn't the town retain those expertise? Because if I pay somebody, they're working for me.
Yeah, I understand, Gina. I think that's a really good question because it comes up all the time. So I'm going to try to take them in the order in which you presented them. And if I miss any parts of the question, please remind me and I'll follow back up at the end.
Thank you.
So you're very welcome. So the first part of your question is, was there a standard? Is there a standard that municipalities have to follow when evaluating applications? And the easy short answer is yes. And the standard depends on what the application is. So I'll give you two examples with using the variances that we were discussing earlier, since it's most accessible to the conversation we were just having. So the standard for a use variance is that the applicable zoning regulations and restrictions have caused unnecessary hardship. And to prove unnecessary hardship, that's a legal term of art. That means that they need to demonstrate that for each and every use permitted in the zoning district where the property is located, that the applicant cannot realize a reasonable return on their investment, that the alleged hardship relating to the property is unique, that the requested use variance will not alter the essential character, and that the alleged hardship is not self-created. So that's the standard for use variance. There's a similar balancing test for area variances. I actually won't read all the elements because it's just a statutory test. But that's just to say, I'm sorry. That's just to say that the statutes for use variances and area variances have the elements required for the board to consider in deciding whether to grant or deny them. They're also required to grant the smallest variance necessary to achieve the benefit sought. And use variance, I'm sorry, special use permit, often in the code will set forth the standard for evaluating or the factors to consider. Then those are the standards by which the board considers the application, the factors in the application that need to be considered, the balancing test, etc. So you have the test, and then you have the standard by which they need to decide. So the standard of review for these boards is what's going to be called arbitrary and capricious, abuse of discretion, made in violation of law or lawful procedure, or not based on substantial evidence in the record or without a rational basis. Excuse me. That's all kind of one standard of review, but they're tied together.
So how is hardship defined? Is it only financial hardship? Is it, loss of customers? Just briefly, like, is it just financial?
It's a very, very, very high standard. The hardship is that, and I'll read this, that for each and every permitted use of the property, the applicant cannot realize a reasonable return. So that's the cannot realize a reasonable return. So that you need to look at every single use permitted. And moreover, and this is getting a little bit into the weeds, but it's going to, kind of indicate to you why it's so important to have experienced attorneys present when you're doing these applications. Excuse me. The reasonable rate of return element needs to be proven by what's called dollars and cents proof. And that's another legal term of art. It comes from court decisions. And what it means is you can't just go in your application and say, I need a use variance because all of these uses are unprofitable. The end. That's not enough. You need to have dollars and cents proof, which means you need some documents, data, specific information, which the court has identified as being relevant, that proves that each of the uses cannot realize a reasonable rate of return. it's a very high bar. They don't want people to just say, well, this other use would be way more profitable, so I want permission to do that instead. It's actually a much higher standard than that. And then the second part of your question, Gina, I believe related to whether municipalities, when they've received applications, can charge the applicant for the cost of the board hiring professional services to review the applicant's application. Yes. So the answer to that is it depends. They are allowed to do that, but they need to create a mechanism to do that. A lot of municipalities do have it in their, rules, procedures, laws. And when we represent municipalities, we are always looking for that because municipalities don't want to be in a position where they get a really huge application come in and the applicant buries them and they don't have the funds to hire their own experts. So there is a provision that allows municipalities to create this right for themselves, right? Which is that they can charge the applicant if they deem that they need professional services to evaluate it, the cost of doing that, because they also don't want to be in a position where they're only relying on an expert hired by the applicant who works for the applicant. They want independent expert that's hired by them. So it's hired by the municipality, paid for by the applicant, so that the municipality can get independent, kind of like third party view of the application and kind of reality check what they're being told by the applicant.
Is there a threshold? Like when we determine, like, am I charging you $8,000 just because I want to take more money out of your pocket? Or is there a threshold or negotiation? They pay half, the applicant pays half. I mean, what have you seen? Because it seems to me that they could just charge whatever they want. And who makes the decision on who the expert's going to be using my money?
The municipality would likely choose, but they're looking for they're not trying to pay more than they have to. I don't know off the top of my head what the limits would be. Obviously, it would have to be related to the application that's being reviewed, and it would have to be for expenses actually incurred. They can't waste funds. They can't,
So does that mean that the applicant would have the right to see those records? So if my client had to pay $8,000, but through the process, the town board only needed $3,000, would he be entitled to a refund?
he would likely only be charged for the expenses that were actually incurred. I'm not
They made him
aware
pay
of a municipality.
$8,000. They made him pay $8,000 up front. And then they went out and hired someone.
Yeah, so
It wasn't like the board hired someone, incurred charges, and then back charged the client. They made my client pay $8,000 up front.
yeah, I'm not sure in that situation, maybe they got quotes for other things that they didn't end up needing. Maybe it'll be refunded after. Without knowing necessarily all the details, it'd be hard to say for sure. But if it's not used by the municipality to pay for the professional services, and the application has either been granted or denied, I would look to the municipality for the rest of that. And I think they would likely be open to talking to you about it. If they have a reason for wanting to keep it, they would likely be able to tell you what that is. Sorry, I really need a lot of water today. Any other questions? So before I go, I wanted to mention that we have some blogs on other areas of law that tend to be really relevant to people in these areas. So I would encourage anyone that wants to check out our blogs to look at our website, thezoglingroup.com. We also have case studies that show some of the examples of cases, and they tend to be things that reoccur. Some of them are pretty unique, but some of them do reoccur. You can take a look at those. We have client testimonials and contact us information.
Bob,
as
do you
well
want to
as-
unmute yourself and ask your question?
Sure. It's more of a support for what Jacob has been telling us. It doesn't happen to be a business issue, but I'm quite sure when he was talking about setbacks earlier and that type of thing that might jump up and bite you. I had that happen with me with a house that I owned for about, oh, let's say 20 years, and went to sell it, and it was about 50 years old. And we had a fence in the back, which had been there for probably 50 years. And all of a sudden, somewhere in the requirements for selling it, by the way, this fence was on my property, maybe back a yard from the property line or something like that, 3 or 4 feet. And for some reason, it was not far enough. Even though it was on my property, and it required me to get the approval of 2 property owners that bordered this fence in the back before I could sell it unfettered. And so I was able to luckily do that because the fence was actually in the middle of a sort of a woods, and nobody cared. And so I was able to go right through it. But the point I'm making obviously is, surprise, there you are coming down to the wire. And if you haven't gotten the proper inspection or the proper representation, guess what? You're going to get delayed, is my point, and run into some red tape. So Jacob, I guess you can comment on that if you wish.
Oh, absolutely, Bob. I mean, it's kind of funny. I on Halloween this year, I did a LinkedIn post of, what's the scariest zoning and land use problem you've seen, right? Is it a purchased a property that ended up being a nightmare, had an oil spill that needed to be remediated, or problems with a neighbor, right? And
Sure.
Things like that, where something with your home comes up after 20 years, is not uncommon. Sometimes these issues sit dormant because no one is doing anything that kind of triggers it, or triggers the secondary impact, right? So they can stay dormant for a long time and then pop up and cause a lot of headaches. So thank you for sharing, Bob.
I don't know whether they passed the law in the meantime or something, or changed the setback requirements, but there it was. And thanks for the insights.
Well, one interesting thing, and not that this applies to your issue or not, but one interesting thing that comes up a lot in older communities, right? And here in upstate Western New York, we get a lot of older communities, older properties, older businesses, where if a code was enacted for the first time or changed after a use had been already started, you end up what's called a pre-existing non-conforming use, which means this use was legal when I started doing it, and then the law changed and made what I was doing illegal or non-conforming. And sometimes that happens with fences built 50 years ago, right? Maybe the law didn't require that setback 50 years ago, and that's why they built it there. So you end up what's called pre-existing non-conforming uses, which essentially just means that a use that existed prior to it becoming illegal can be allowed to continue. Essentially, this is colloquially referred to as being grandfathered in, right? The prior use is grandfathered in because it's a pre-existing non-conforming use, and to require that use to stop, after it had been legally operating for so many years, would affect a taking. So there's land use and zoning and municipal law intersecting with constitutional law. And as I always say, zoning and land use is where the rubber meets the road. Most people will never interact with constitutional law their entire lives until they have a zoning problem.
Sounds like we need you at a minimum for understanding what the law says. So thanks a lot.
Well, you got my number, so if I can be of any help, I'm happy to be a resource.
Very good.
So Jacob, in that case, he was grandfathered in. Was it because he was going to sell that now he needed to bring it up to code?
Well, I don't know if he was grandfathered in or if his, what his situation is. What I was just saying is there are situations where people get grandfathered in. And what that means is if you have a use, let's say, you were operating a convenience store in this area, and then they enact a zoning code and suddenly your area is residential and not allowed to have commercial. Well, that convenience store can continue to operate so long as it is continuous. Pre-existing non-conforming use problems come up when you have a pre-existing non-conforming use. It existed prior to a zoning change, and then for one reason or another, that use is discontinued. Then municipalities sometimes adopt arguments that, oh, you discontinued it for long enough that you abandoned that use, and it's not a taking anymore because the use was abandoned, so you don't get a pre-existing non-conforming use. And other issues come up when someone has a pre-existing non-conforming use but wants to tweak it, right? And they're like, well, I was a restaurant, now I want to be an event space. I was a bar, now I want to be a liquor store. Or they want to expand it. They're like, I was this small building, I want to, build out more. Expansions of non-conforming uses are usually disfavored by municipalities, and oftentimes we'll see municipalities taking any opportunity to try to clamp down on non-conforming uses, right? Because the whole idea of a zoning code is that you kind of group things together so that the secondary impacts don't harm each other. So maybe a little bit more than you were asking for about pre-existing non-conforming uses, but it does come up with businesses a lot because they'll buy a property thinking I can use it for this because it's been used for this for a long time, but they don't kind of keep it continuously operating. They shut down for a little bit, or something else happens that causes them to not start up right away. And then their non-conforming use could end up being abandoned on accident. Those are problems that can really throw a wrench, because if you bought a property expecting to continue a business or a use that had been there for a long time, and you just don't open it, fast enough, you could end up in some trouble. And that can have pretty serious impacts if you acquire the property with that intent.
Yeah. So for small business owners, what tasks or activities would you recommend that they engage in prior to an application?
Well, I would definitely talk to an attorney before making a municipal application for a variance. You don't want to have something that's so important to your business that you can't operate without it, and you get denied and have to wait a year to reply, or end up having to go to court to challenge. And they're not insignificant costs to go to court to challenge these things, and go in with a less favorable record than you would have been had you had an attorney to begin with. It's one of those things that I know I know an attorney to help with an application can be a daunting expense, but an even bigger expense is paying the attorney to commence a lawsuit.
So what about attending board meetings, having a conversation with members of the board, getting the lay of the land? Would you recommend those activities?
Yeah, it's important to have good relationships. So sometimes, they'll have working sessions. Often, we have communications with municipalities when we're getting ready to make an application. We're talking to them saying, this is what we expect it to be like. This is what, we understand the process to be. Just making sure that we're giving them everything they want. That we're on the same page about the requirements and the process. And that we're showing them that we're trying to be good neighbors, that we're trying to be participants in the community. And if you can have those conversations with the municipality early on, if you can have that relationship with, the members of the community, then maybe you can nip in the bud this, NIMBYism that sometimes occurs. And a little investment in avoiding those issues at the beginning can save money in the long term and can be really important for making sure the business gets off on the right foot.
Thank you.
You're welcome.
Any more
So,
questions? Sorry, Jacob.
No, I was gonna say the exact same thing, but you know, so that was just us trying to say it in stereo.
As a reminder, with the PowerPoint presentation, you will be sent a link to the presentation on our YouTube channel. So if you want to rewatch it. Okay, going once, going twice. All right, thank you so much for your time. And next month, June is our last one for the year. We take a break in July and August. And it will be on AI and ChatGPT, so please join us. And thanks again, everyone, for attending.
Thank you,
That should be
Jacob.
a fascinating topic. Thank you
Mhm.
to the library and Small Business Development Council for the invitation and for everyone for having me. Hope you have a great day.
Thanks.
Thank
Sure.
you.
Thanks a lot.